express or implied. So express is when you expressly state the terms. So it means like if you write it down, or if I say, hey, I will employ you to do this, right? Then you have like an express agreement. Or an implied agreement. The law deals with things that are implied all the time. So if I make it seem like I'm going to pay you to do some work, but we never actually shake our hands, or we never actually, write a contract, you could argue that you have an implied employment agreement, all right? So any agreement, whether it's written or spoken, and whether you expressly stated it and, signed or shook hands, or if it's just implied based on your actions, where one person is agreeing to employ somebody else and the other agrees to serve as the employer-employee, and there's this contract of apprenticeship, right? Okay, so in other words, there's a lot of different things that can apply, okay? The reason why I bring this up is because, again, just to reemphasize, when we're talking about foreign domestic workers in Hong Kong, you really don't have any of those other options for the most part. It's primarily going to be linked to that specific contract, that standard employment contract. That employment contract looks like this. Now, again, if you look at up here, you can see that this particular contract is L637269. And the reason why that's important is because every single domestic worker employment contract in Hong Kong is actually pre-numbered by the Hong Kong government. Now, if you ask me, I think this is extremely inefficient, and I wish they would stop doing this. But what it means is that they actually have to physically print out every single contract, and you have to have that number that is up there. They don't allow the digital or e-processing of these contracts, which is a huge waste of time and money for the Hong Kong government. And it also makes it very difficult for you as an employee or as an agency in managing and dealing with these contracts. But whatever, can't change that right now. You can also see down at the bottom, there's a barcode, right? And that barcode way down there, right here as well, that is the way that they can scan and go to that specific agreement. All right, and so there are 4 pages to the standard employment contract. And so what we're going to do in this topic 1 is we're going to go through most of these clauses and discuss about what each specific clause means. All right, so let's go into it. First, we're going to talk a lot about the contract, quote, parties. And so I want to make it clear, when we're talking about a party in the law, we're not talking about a party where you're dancing with your friends or doing karaoke. What this means is a party is a person or a company, because companies are legal persons, but it's a person that is tied to that contract. Okay, so in the case of a domestic worker employment agreement, or really any employment agreement, the parties are going to be the employer and the employee. So again, in this particular case, you have the foreign domestic worker is the employee, and you have the employer, which is probably going to be a family. If you're working in Taiwan, let's say you're a factory worker, you're a foreign worker that's in Taiwan, then it could be the factory owner or the factory company, that like the name of the company itself is one party, and then you as the employee would be the other party. Okay, so when I talk about parties, again, we're not talking about like a dance party or a karaoke party. We're talking about people, which includes companies, that are signatories, meaning they sign these contracts. All right. So the very beginning of the employment contract, the very top, you can see it outlines the parties, the contract parties. Now, this is actually really important for if you are a migrant worker. Why is that important? It's pretty obvious, right? Like the contract parties, the employer, employee, everybody knows that. You can't have an employment agreement without an employer or an employee, right? Well, here's the thing. A lot of people, when they try to take advantage of domestic workers, or maybe they're a bad employer that has been blacklisted from the system. That blacklisted means you're not allowed to do it because maybe you hit one of the domestic workers, and so the government says you can't hire one anymore. Well, what you'll find is the employer that's listed as the contract party oftentimes is not actually the person that you're working with. Okay? And this is really important because the name of the person on that contract, that is your employer. And so you have to be really careful to make sure that that name actually matches the person who you're working for. a lot of domestic workers, they'll be hired by someone, maybe the grandma or maybe the husband in the family, but then they're actually working for an auntie or somebody else, and maybe even asked to go work in that other person's home. And as we're going to discuss in a moment, that's kind of a problem. So you have to understand who the contract parties are, and therefore, who is responsible as your employer under the agreement. Okay. So the place of origin in clause 1, that is obviously the place where you originate from. That means the place where you're from. And you want to make sure when you see your employment agreement that clause actually reflects the address where you're from and where you want to return to, because that's going to be the basis for your return ticket or the fare, the money that they give you that's provided to the employer when it's time for you to go home. All right. So take a look at that. It's pretty simple. Just make sure it has the correct address. A lot of times agencies, when they're filling them out, they actually don't put the correct address, or they'll put, let's say, maybe you live in Iloilo, but then you travel to Manila for your training center and employment agency, and then they'll put Manila. Well, that might mean you're going to get less money to fly back because they're going to say your place of origin is actually Manila, and it's not going to include like the bus fare to go to Cagayan or something else. Okay. Clause 2, this is the contract timing, the timing of the contract. Now, for the date of commencement, commencement means the date or the time that the employment begins. So the date of commencement is the date that the contract starts. Okay, so for your date of commencement, for the employment contract, you need to look at the date on your work visa and the date that it was issued. All right, this is a little bit tricky because a lot of people think it's the date on the contract itself, and that's actually technically not true. Under Hong Kong employment law, the date of your employment commencement is the date on your employment visa. All right, so make sure you take a look at that. The reason why that's important is because your visa might start on a particular day and your contract starts at a later date, and so that can impact you if they're looking at things like entitlements to try to see how much they owe you upon termination. All right, so clause 3 deals with residence and work address. So I already addressed this earlier. The key thing here is to make sure that the residence and work address on the contract actually match where you are working. Because if they don't, that is a violation of not only the employment ordinance, but also immigration law. And if they find out, then you could potentially get into trouble. Now, this is a really tricky thing, though. A lot of you have been asked to work at a place that is not actually the residence or work address. And so you're kind of stuck in a tough position. Let's say they want you to go to their grandmother's house because she's sick, and they want you to stay there for a few days and to take care of her. Or maybe the family's traveling into China, and they want you to go into China with them and to take care of them while they're in China. Should you do that? Now, we're not going to answer that question right now because it's kind of a tricky thing. Part of it is the legal side. Legally, you're not allowed to work anywhere else except for the place that is the address on your employment contract in clause 3. But I also understand that practically speaking, if you're not willing to do those things, if you're not willing to go to China and cook and clean while you're there, if you're not willing to go to the grandma's house or an auntie's house or something and cook and clean while you're there, then you might run the risk of losing your job. And I do understand that's a tricky thing. And so we're not going to tell you what to do. I'm only going to tell you that legally speaking, you are only allowed to live and work in the address that is on clause 3 of your employment contract. You're not permitted to live and work in any other address, even if the residence in the other address is owned by your employer. Let's say they have 2 houses, right? Maybe they have a house in China, or they have a house like a weekend house that they go to. Technically speaking, you are not legally allowed to reside or work in those other addresses. Now, here's an interesting thing though. Does it mean you can spend the night someplace else? Yeah, it generally does. As long as you're not residing there, which means plan to live there full time, you can actually spend a weekend at your friend's house or maybe at a boarding house, or go stay at a hotel for the week on a beach in a different part of Hong Kong if your employer allows it, and if you and your friends want to go celebrate a holiday or something, right? That is technically allowed, even though a lot of employers will not allow people to do that, or there's a mistaken understanding in Hong Kong to say that you can't actually spend the night in any other location. You can, as long as your employer doesn't get you into trouble, and as long as you're not planning to reside there full time. Okay, so Clause 4, A and B, goes through conditions of stay. Conditions of stay are part of employment and immigration law that are basically saying what you are allowed to do while you are in Hong Kong. So you are not a Hong Kong permanent resident or citizen, and therefore you're restricted in terms of the types of activities you can engage in while you are in Hong Kong. All right. And so, for example, as I just said, one of the major conditions of stay is that you are only allowed to work and reside in the home of the employer that's listed in Clause 3 of the employment agreement. Okay, pretty basic. Well, what else? Well, you're only supposed to perform domestic duties. Now, what are domestic duties? It's the basic stuff you'd think about: cooking, cleaning, shopping, right? That basic type of general family care. What it means, though, is you're not allowed to, for example, work in your employer's store or office. Maybe they want you to go clean their office. Technically, that's not allowed. Or, as I said, maybe they want you to perform domestic duties in a different address. That is also technically not allowed. So it's a little bit tricky. Part of it is, what are you willing to put up with? Because a lot of employers will really be forceful, and they say, hey, if you want to be employed by me, you have to go do these things. But at the same time, it's important to protect yourself and make sure that you're not putting yourself at risk by going and working and doing things you're not really supposed to do. Now, it's important to understand that violations of these conditions can make you and your employer liable and potentially subject to prosecution. Prosecution is when the government comes after you and files criminal charges against you. So in the case of a domestic worker who is working at their employer's offices, if the government finds out, they can prosecute you, they can put you in jail, and potentially send you home. This actually happened to someone that I know. There was a domestic worker that I know who, unbeknownst to her employer, was spending her evenings and weekends working at a restaurant doing their dishes. And unfortunately, a jealous person called immigration, and the immigration officials went there while she was working, and they grabbed her, apprehended her, and took her actually to prison. So she had to spend 60 days in jail in Hong Kong, and then at the end of the 60 days, she was deported. So not only did she have to spend time in jail, she also lost her job, and she got sent home. And so, you have to be very careful to make sure that you're protecting yourself in those types of instances. Okay, so what do domestic duties include, right? Some people are asked to perform massages. Some people are asked to wash cars. Some people are asked, like I said, to go into China and to take care of the family while they're traveling. Are those domestic duties? So, for example, is it part of your domestic duties to massage your employer or to help them in their business? I want you to take a moment and think about it. And in the comments to the course, let's go ahead and perform or write down, type out some of the things that you think are legitimate domestic duties, and maybe share some things that are not legitimate or potentially not domestic duties. All right. Okay, moving on to Clause 5. This is about monthly wages. Now, wages are your salary. It's the amount of money that you're paid to perform your work. And so it's important to understand that under the Hong Kong Employment Ordinance, it is actually unlawful, not allowed, for the employer to pay below the amount stated in your contract or the minimum allowable wage, the minimum wage. All right. Now, as I said, Hong Kong employment law is the same for you as it is for me. But this is actually one of the areas where Hong Kong employment law is actually quite different, because the minimum wage for a foreign domestic worker is actually very different than the minimum wage for other workers in Hong Kong. In Hong Kong, most workers have a minimum hourly wage. It's just called the minimum wage. And so therefore, an employer has to pay them a certain amount per hour. But for foreign domestic workers, the Hong Kong government says it's too difficult to gauge how many hours a day you are working. I think that's unfair, by the way, but that's their rule. And so what they do is, instead of paying an hourly wage, because, I mean, a lot of domestic workers are working 15, 16, 17 hours a day, which is very unfair, but unfortunately it's allowed. If you actually charge the legal minimum wage, then for a lot of local families, that would be quite expensive. Now, again, I think that it should be expensive. If you have a full-time, someone who's working for you full-time, if they're working 15, 16, 17 hours a day, which they shouldn't be in the first place, but if they are, they should get paid a lot of money. But again, that's not my decision. And so what the Hong Kong government does is they created a minimum allowable wage specifically for foreign domestic workers, all right? So if you are offered a higher salary than the minimum allowable wage, maybe you're really talented or you have a great employer and they say, I'm going to pay you $7,000 per month, and that amount is actually written in your employment contract in Clause 5, then they would be required to pay you that amount and would not be able to go down to the minimum allowable wage unless you renegotiate the contract. So make sure they're paying you what is owed. Okay, so what is the minimum allowable wage, and how much do they have to pay you for food? Well, first let's talk about food. In Clause 5B, that's where it talks about accommodation and your food and food allowance. All right. Now, first, with accommodation, your employer or potential employer, they have to provide you reasonable accommodation. Okay. Well, what is reasonable? I don't know. The Hong Kong government doesn't really define it very well. And, if you Google things and maybe in your own experience, you find that foreign domestic workers have very, very, very different accommodations. A lot of domestic workers have their own room with a nice bed, their own toilet, shower, etc. But a lot more domestic workers are sleeping on the floor in a children's room, or they're sleeping in a closet, or sometimes even in the living room. That is not supposed to happen. It is supposed to be reasonable and private accommodation. But again, I understand for a lot of domestic workers, even if they're not given reasonable accommodation, they don't want to say anything because, they don't want to lose their job. So just understand, make sure you talk to a potential employer ahead of time. Make sure you understand what is the accommodation that they're offering you. And if it is not the actual, maybe they lie to you or they don't give you complete information about the accommodation and where you're sleeping, your bed, how much space you have, whether you have privacy, then that might be something that is worth bringing up to the Labor Department or other authorities. So let us know if you feel like you do not have reasonable accommodation. Okay, in terms of food, employers have to make sure you get fed. And your food is actually covered in the amount of wages that they pay you. Okay, in other words, your employer has to make sure that you're getting reasonable nutrition and reasonable food. Now, that doesn't mean you should never have to pay for any food. I think a lot of domestic workers, they think, well, if I want a specific type of food, the employer should have to buy that for me. Or the employer should have to pay for my meals if I go to McDonald's or something. That's not the case. A lot of domestic workers, they'll pay for food, that's specific, that they want, or when they're going out with their friends, all right? That's okay. But what you need to make sure is if your employer is providing food for you, then you are getting good, reasonably nutritious food. And for a lot of domestic workers, that can be a challenge because maybe you are Muslim and you the family always eats food that has ham or pork products in it. And unfortunately, a lot of domestic workers, they are malnourished, meaning they don't get enough nutrients because they're not getting enough food or they're not getting the right types of food. If that is the case, again, speak to your employer. A lot of times it's just miscommunication. We've talked with a lot of employers and they have no idea that their domestic worker, their employee is starving. They don't realize they can't eat the food or they won't eat the food. So the first thing to do is to speak to your employer and say, hey, I don't feel like I'm getting enough to eat, or I don't feel like I'm getting the right amount of nutrients. And if that's the case and they won't help you, then maybe you can raise that with somebody else. But what if they don't want to feed you? Or what if you would prefer to eat something else? Well, if your employer agrees, then instead of giving you food, they can give you a food allowance. And that food allowance is actually mandated by the government in terms of the amount of money they have to give you. Okay? So, in terms of payment receipts and making sure that you are being paid properly every single time that you are paid, make sure that you get a very clear, accurate receipt. Now, an employer is required to provide you with a receipt for your salary payment. A lot of times that doesn't happen, but it's very important that you make sure that does happen, because it doesn't just protect you, it also protects your employer, because sometimes people just forget. So it's just good practice to get into the habit of making sure that you and your employer actually issue those receipts every single month. Now, what should be on those receipts? Well, it should state the wages that were received, the date that the wages were received, the amount of any deductions, and the reasons why the money was deducted. And again, it's very, very important that you check your receipts and make sure that they are accurate and that all of the money that it says you received on there, you actually received. Do not sign anything unless you actually receive that money. Okay? Again, do not sign any salary receipts unless they're accurate, unless they state what you got paid. And make sure that you keep a personal record of all the payments that are not only received, but also what is owed. This is very, very critical, because if later on you end up having a claim with the labor department, or if you have to go to the police or something, you need to keep accurate records. And if you have a lot of records, then the government is much more likely to trust you. Okay, so coming back to the monthly wages and the minimum allowable wage, the minimum wage, the Hong Kong government updated both the minimum wage and the food allowance in September of 2019. Okay, so let's take a guess. What do you think the minimum allowable wage and the minimum food allowance are? I'm going to give you a second to think about it while I get a drink. Okay, let's see if you know what they are. The minimum allowable wage since September 2019 is 4,630 Hong Kong dollars. All right, and the minimum food allowance is 1,121. Now, if you are not being paid that amount, then please make sure that you speak to your employer and make sure that you're getting at least that minimum allowance in terms of your wages, but also in terms of your food allowance. All right? Now, rest days and holidays, Clause 6. Domestic workers are entitled to all of the same rest days, holidays, and paid annual leave that other employees in Hong Kong are entitled to under the employment ordinance. Again, this is a really great thing. In Singapore, in Taiwan, in the Middle East, foreign domestic workers are not given the same rest days and holidays as normal employees in Hong Kong, and you are here. So it's a really great thing. All right, so oh, and by the way, I should point out that if you are ever wondering what are those days, well, you can just Google or look at there's a bunch of websites you can go to in Hong Kong. Just Google Hong Kong holidays, Hong Kong statutory holidays, or Hong Kong whatever, and you'll be able to find a list of them. The Hong Kong government provides those lists, and it's generally pretty clear. Now, in Hong Kong, there's a distinction between a statutory holiday and a non-statutory holiday. Statutory holiday is a day when everybody gets off work no matter what, more or less. And a non-statutory holiday is a government-recognized holiday where employees don't necessarily get that off. It's up to the employer. And recently, the Hong Kong government has put out the idea that they're going to make all holidays statutory holidays, which means if that happens, then all of those holidays would be mandatory rest days. Okay, so stay tuned. Hopefully next time, maybe a few months from now, if you're watching this will be out of date, and all of those holidays will now be statutory holidays. Okay, so Clause 7 deals with passage to the place of origin. Again, we talked about the place of origin, and it's stated on your contract. And that is the place where you're from and where your employer is legally obligated to pay for you to return to. All right, so again, clause 7A says free passage. And so this means that the employer has to pay for the cost of transport between the airport in your home country and your hometown if it's located in a different city or province. Okay, so let's say that you're from Guimaras and your employer flies you to Iloilo. Now there is no airport in Guimaras, and so the closest airport would be in Iloilo. So they fly you to Iloilo, and then they also have to pay for the transport from Iloilo over to your home in Guimaras. All right. And in 7B, it says that you're also granted a travel allowance, and that is 100 Hong Kong dollars per day of travel. So let's say, you fly to Manila, and then you have a 2-day bus ride to your home in the very, very northern end of Luzon, right? Like the Cagayan, I think that might be up there. So let's say you're going to Cagayan, and it takes maybe 13 hours on a bus. Your employer is required to pay you 100 Hong Kong dollars per day that you'll be traveling. All right. These are not a big deal. And again, you probably wouldn't push very hard for this type of money, but it's important to understand that's technically what they owe you. All right. So clause 8, processing fees. The Hong Kong Employment Ordinance is very clear that if you have paid for any of the fees listed in clause 8, then you are legally allowed to get a refund. All right. So medical examination fees, authentication fees by consulate, your visa fees, your insurance fees, other administrative fees from government agencies, all of those things are reimbursable either by your employer or by the employment agency, depending on the agreement that the employer and employment agency have. Some employment agencies will pay for those things and they will reimburse you directly. Sometimes the employer has to reimburse you. Just understand that it is legally your right to have those things reimbursed. So if your employer, requires you to get a medical examination, then they have to pay for that as part of the employment process. All right. Clause 9 deals with what happens if you get sick or if you get injured. And so obviously this is really important because if you are sick or injured, unfortunately, a lot of times employers in Hong Kong, they don't want to pay for this. And there's a lot of really sad stories about where domestic workers maybe get breast cancer or some other type of very, very, dangerous and maybe even life-threatening disease. And a lot of domestic workers don't realize it is actually the employer's obligation to provide free medical treatment. Okay, so Clause 9A, free medical treatment, irrespective of whether the employer has obtained medical insurance or not, except when the migrant domestic worker seeks treatment outside of Hong Kong on her own, they have to provide free medical treatment. So let me say it this way. You get free medical care even if your employer did not obtain medical insurance. Okay. Now, what if a lot of domestic workers, they want to go home? So I had several cases where domestic workers, again, they have maybe breast cancer and they want to go home to the Philippines so they can be with their family. If you choose to do that, then you might have to pay for that yourself. So you have to be very careful with what you agree to. But if you stay in Hong Kong and if you are still an employee and you contract the illness or disease while you are an employee, then your employer has to provide free medical treatment. Now, in terms of employment compensation, if you are injured, your employer also has to provide compensation for injury from an accident that is out of and in the course of employment and occupational disease resulting in total, permanent, or partial incapacity. So what does that mean? So it means if, for example, you're cutting something and you cut your hand and you become injured, or if you keep doing the same thing, maybe you're lifting something that's heavy and you hurt your back, then the employer has to provide compensation based on the Hong Kong Employment Ordinance. Now, if that happens to you, don't rely on this. Go and seek some help and get some advice because there are, some calculations that need to be made. And so it's important to speak to someone who can help you. Okay, so 9C says permanent unfitness for service. Now, unfortunately, if you are eventually unfit for service because you are certified as permanently unfit, then your contract can be legally terminated. And so again, if that happens to you, or if you feel like you've been terminated unfairly, then you should reach out to a lawyer or an NGO to see if they can potentially help you. All right, so clause 10 and 11 dealing with termination. So clause 10, it says that either party can terminate the contract with 1 month's notice in writing or 1 month's wages in lieu of notice. Now, this is really important because if you want to terminate the contract, or if your employer wants to terminate the contract, you have to provide 1 month's notice. And let's say you don't want to provide 1 month's notice. Under normal circumstances, you would actually have to pay them 1 month of salary. Okay, and conversely, if they terminate you without giving you 1 month's notice, then they would also have to pay 1 month's salary, 1 month of your salary in lieu of notice. In lieu means instead of. So wages in lieu of notice means they're going to pay you money instead of giving you that notice. Okay, now clause 11 deals with termination without notice, and it does say that either party can terminate the contract in writing without notice or payment in lieu of notice under certain circumstances. So what are those circumstances? Well, for the employer can, it's really vague, and it gives the employer a lot of power, and a lot of domestic workers get terminated unfairly under this clause because it doesn't really state enough specifics about what the employer can say in order to terminate without notice, right? So in other words, unfortunately, the employers in Hong Kong have most of the power, and they can make up excuses that are very difficult to prove. Okay, so what are the reasons why an employer can terminate you without paying you 1 month notice or without giving you 1 month notice? Well, if you willfully disobey a lawful and reasonable order. Well, what does that mean? If you refuse to mop the floor with your, on your hands and knees, is that a reasonable and lawful order? It's very difficult to say. Or if you misconduct yourself, such as being, quote, inconsistent with the due and faithful discharge of duties. Well, again, what does that mean? It just means you're being really inconsistent, I guess. It means that you're not really performing your duties. Maybe you're being really, really lazy, and they've warned you several times. The third one is if you're guilty of fraud or dishonesty. And again, I mean, it's very difficult to prove that you weren't being dishonest. If they say that you stole something, or you've been lying to them, well, it's very difficult to prove that that is not true. And then finally, the last one is habitually neglectful in your duties. And so again, let's say you're constantly late, you're constantly having problems, and they keep warning you over and over and over again. Then the employer may have the right to terminate you without giving you any additional notice. Okay, so, or at least not 1 month's notice. All right, so again, what about if you're the employee? How can you terminate your contract without giving 1 month's notice or payment in lieu of notice? Well, you also, as the employee, you also have some rights to terminate, and these typically revolve around, fear, or if the employer is really, really being disrespectful and abusive to you. And so, if maybe they hit you, and you're scared they're going to hit you again, or maybe they've been really verbally abusive to you, and they keep yelling at you, screaming at you, and being just nasty to you. If that happens, make sure you document it, meaning like take video, take photos, save text messages, whatever it takes. That way you can show the police or the Employment Agency Administration, Labor Department, and you can show them that your employer has been very, very abusive and is not treating you appropriately, and therefore you will not owe them 1 month's salary, and you can leave immediately. Okay? You should definitely not stay in any situations where you're being abused or mistreated. And if anyone out there does hear this and you are being abused or mistreated, please make sure you reach out to the Empower You team immediately and let us know, and we'll do everything that we can to provide some assistance to you. All right, now Clause 12 deals with what we call notification of termination. Now, what happens is when you have been terminated, or if you terminate the contract, since you're not a permanent resident in Hong Kong, you're a migrant worker, you have to notify immigration within a certain period of time. And so if your contract is terminated for any reason, then you have to notify them within 7 days, right? And 7 days notice you actually have to submit something that's called a notification of termination of employment contract with foreign domestic helper. That's the name of the form. And you can get that either online, or you can go to the immigration department and get that. The employer is really responsible for this. And so if you're terminated, then a lot of times the employer is the one who submits that form. But you just want to make sure that's submitted in a timely manner, so that the immigration doesn't say that you were trying to overstay or anything like that. Now, the problem is, once you provide notification that the contract has been terminated, foreign domestic workers are usually only allowed to stay in Hong Kong for 2 weeks. Okay, it's called the 2-week rule. And so it's a little bit tricky. Let's say your employer just terminates you immediately, right? Because they say you stole something, which, maybe you didn't do. Do you really want to go and notify immigration immediately? Because then that 2-week time period, starts ticking, and maybe you want to wait to see if you can find another employer. So go talk to an NGO, talk to a lawyer, contact us, because that's a very dangerous game to play, because I understand you want to stay as long as you can so you can get a new employer, but you also need to understand the law says that you're supposed to notify immigration within 7 days. Okay, so again, when you do this, make sure you check the dates for accuracy, because it's the date on your visa and not the date on the employment contract that they're going to go for. And make sure to check that the reason for termination of the contract is accurate and clear, because and if it's not filled out, then make sure that you cross out that space, because you don't want that to be added in later on if you're going to sign the document. And okay, so just in other words, protect yourself. Make sure that when you are terminated, or if you are terminating, then you accurately go through these steps in order to protect yourself. Clause 13 deals with renewal of contracts. And obviously, if things are going well with your employer and you want to renew the contract at the end of the term, that's fantastic. And under those circumstances, you get special consideration. Usually you don't have to leave Hong Kong to process that visa, and you can just, continue to work. Again, depending on the circumstances. And the process can be handled without an agency. So if you normally would work through an agency, renewals of contract, even if you are Indonesian, they can be handled directly between you and the employer and Hong Kong government. So in clause 13, it says, if the parties agree to renew at the end of the contract period, then the employee, that's you, will, at the expense of the employer, meaning the employer has to pay for it, can return to the place of origin for at least 7 days. Okay. Now, that can be paid or unpaid leave. So check your contract and see what you agreed with the employer. Additionally, domestic workers can defer home leave on renewal of contract, but will only be issued a visa for 1 year. And domestic workers have to leave Hong Kong on or before the visa expiry to extend for another year. Okay. So as I said, you can process it in Hong Kong. You may have to cross the border and then come back in order to process that visa. But you don't necessarily have to leave and go through like a long 2-month contract process like you would normally have to do if you get a new employer. Okay, so in terms of on clause 15, we're almost done here. These are permissible variations. Permissible means allowable, and variation means change. So this means the things that you can actually change in the employment contract. Now again, under Hong Kong law, you do not have very many options with your employment contract and with the clauses in your employment contract. So you do not have very many permissible variations. You have to stick to the clauses in the employment contract. And again, I think it's very unfair, but what I think doesn't matter. That's just the way that it is right now. And so clause 15 does outline a few areas where you can have some variation and change negotiate some change into your employment contract. Okay, so any other variation other than included in clause 15 is probably not going to be allowed and would be illegal. Okay, so be very careful. Okay, so extension of the contract period for a maximum of 1 month by mutual agreement and with approval from the immigration department. So let's say you're not going to renew the contract, but your employer needs you to stay for 1 month, maybe because she's pregnant or something, who knows. Then if you both agree And if the immigration department agrees, then you can extend the contract for 1 month. Change of the employer's address upon notification. So obviously, if the place where you live and work is changing, then you should notify immigration and they will update your employment agreement. Number 3, changes to the number of people to be served and accommodation arrangement and domestic duties. All right, so let's say they have a baby or an uncle is coming to live with them, then technically you should notify the Hong Kong immigration of that and show them the new employment contract. I will be honest with you, I don't think very many people do that. In fact, I don't know anyone who really does that. But again, if you want to protect yourself, then that's theoretically what should be done. And then finally, if you're going to be driving a vehicle, right? So maybe you are hired as a foreign domestic worker, but then they want to add on driving as one of your duties, or maybe that's your main duty, then that actually has to be approved by the immigration department. So drivers in Hong Kong are usually employed, at least foreign drivers are employed under foreign domestic worker visas, but they have to be granted special permission. I think that's right. Again, if I'm wrong on that, I'll notify you. But I think that's pretty much the way it works. But you have to be given special permission for that because driving is typically not considered a normal domestic duty, right? Okay, so that is the end of topic 1. That is the entire employment agreement. And within this topic, we've talked about all of the clauses. Again, please make sure that you have your employment contract, make sure that it's accurate, make sure that you know where it is, that you signed it. If you have any problems with any of these clauses, if you've been terminated, if you're being abused or having any other challenges, or maybe you just want to leave because you're looking for a better opportunity, then please make sure you seek some help, you get a lawyer, you find an NGO that can help you. Reach out to us if you have any really challenging circumstances, and we'll see you for topic number 2.